Good afternoon and welcome everyone to this event. On behalf of the App Association, I really would like to thank you all for joining us today. We decided to organize this event because licensing of standard essential patents on fair, reasonable and non-discriminatory terms, FRAND terms, is a long-standing issue that has attracted substantial attention in recent times as technological developments accelerate in the proliferation of IoT. For our members, SMEs, particularly those developing devices for manufacturing, agriculture, healthcare, consumer electronics, the ability to either license directly on FRAND terms or get access to fully licensed modules and chipsets is vital for the competitiveness and innovative capacity. So today's conference will explore some of the outstanding issues related to FRAND licensing. We have a host of esteemed speakers today. We'll open the conference with remarks from Vice Chair of the European Parliament Legal Affairs Committee, Mr. Garcia de Blanco. And this will be followed by a keynote address from Mr. Tokarski, the Director of Industrial Policy and Innovation in DG Internal Market, Innovation and Entrepreneurship, and SMEs, who will offer the perspective of the European Commission. Then we'll have two different panels. The first one will be on use-based licensing and hindrance to innovation, which will explore whether certain valuation methodology hinder innovation or foster the growth of IoT. The second panel, antitrust implication in the refusal to license standard essential patents, which we will discuss perhaps one of the most divisive topic at the moment, where to license SEPs and what are the effects of refusing to license to companies. So I leave it up to the moderator of each panel to introduce the speakers, but please note that the biographies are available on the event page of our website. You can access it at actonline.org. Just a bit of housekeeping. Before we start, please note that the conference is being recorded. We will have a Q&A session after each panel. We will try to reply to as many questions as possible. Feel free to drop them in the chat box and the moderator will look at them and put them to the speakers. We'll also be tweeting live with the hashtag SEPsEU. Feel free to join us in this. And all that being said, let us begin. And I will now pass the floor to Mr. Garcia de Blanco, Vice Chair of the European Parliament Legal Affairs Committee. The floor is yours.
Thank you very much, Morgan, and good evening from Spain, from Madrid. Thank you very much to the APP Association for organizing this timely and very much needed discussion, and for inviting me to be part of this exchange to hear, learn, and contribute towards a balanced system for the standard essential patents. The growing number of businesses whose operations, products, and services now rely on standardized technology is leading to the crucial need to set new principles around the licensing of standard essential patents, including for these use in the internet-connected devices, such as those we are carrying in our pockets, and that are many times the means, the core and the aim of our work. Digitizing European industry and the EP resolution. In its resolution of digitizing European industry for the European Parliament, there is no doubt that European leadership in industrial digitalization requires a strong standardization strategy, which includes standard essential patents. This standardization strategy requires, for one side, coordination with the member states and the European Council and European Commission, and two, to be intensive and participated by societal stakeholders and particularly SMEs. In this respect, the EP calls EC, European Commission, to promote the development of open standards, as well as the access to and efficient licensing of standard essential patterns under fair, reasonable, and non-discriminatory conditions as key to promote innovation and research and development in the EU. It's also key to the EP to put our efforts in a European-wide coordinated approach throughout the European standards organizations in relation to international fora and consortia. And when possible, elevate those efforts towards global and universal standards. The European Parliament resolution admits the importance of interoperability, in particular in the domain of the Internet of Things, so as to ensure that the development of new technologies improves opportunities for consumers who should not be locked in with only a few specific suppliers. The importance of standardization resides in, from one side, being crucial in the information and the communication technology and the LOT, consumer electronics, automotive industry, electricity grid industry, for example, rely strongly on standardization as it is the development of smart cities capable of dealing in an efficient manner with issues such as traffic regulation, resource management, and public health. The second hand and interoperability and benefiting consumers by allowing manufacturers to increase the overall size of markets and thus achieve economies of scale as well as increased product replacement. There is one more thing that we should stop neglecting. When we talk about inventions, including important technology standards. In recent years, we have witnessed that patents on standards, in particular standard essential patents, are frequently liquidated. We cannot forget that only by properly licensing, the patents owners are able to regain the investment to create new patentable inventions, which is needed to further develop of European innovation. We all agree that as with any kind of intellectual property, patent owners must be able to enforce their rights against those who infringe upon their patents. However, the observance of FRAND licensing in this process should be implemented to allow an inclusive participation by societal stakeholders, and particularly small and medium enterprises and startups, as they are also key to promote innovation and research and development in the European Union. Today, we may allocate a fair amount of time to talk about the confusion generated by the litigation associated with SEPs, which derive from the potential to disrupt the manufacture, marketing, and distribution of products that include many patented standards. It also raises serious concerns over competition in the marketplace, as well as over the need to maintain interoperability to ensure that the LOT industry develops. Therefore, tensions arise between SEPs, which offers their owners research and development incentives or rewards in the form of monopolistic rights, and standards, which allow for widespread and collective use. As a conclusion, my work as legislator is to find effective ways to balance these tensions and positions in a way that the result benefits all the stakeholders involved in these processes. Therefore, I look very much forward to the contribution by European Commission on the future policy developments related to the standard essential patents, as well as to further discuss ideas that help us, legislators, issue fair licensing practices and guide us in drafting balanced initiatives benefiting the overall stakeholders related to the SEP sector, and by the other side, picturing an optimum scenario of incentivizing the development of new technologies, including standards within a frame of fair competition. bottom line, and in order to summarize everything, we have to look for a balance between confronting interests. In this way, I very much appreciate this kind of efforts in order to put stakeholders and different approaches to this phenomenon in debate in order to find the best way to legislate. Thank you very much, and thank you for the invitation.
Thank you very much, Mr. Garcia de Blanco. I understand that you need to now go and run away to vote in committee.
Yes, unfortunately, I don't have any other option. So sorry, but I'll be so attentive to the conclusions of this panel.
That is fine. We thank you very much for your participation, and we wish you all the best.
Thank you very much.
So we will next hear from the European Commission. And while Mr. Tokarski is readying himself, I will just offer a brief introduction. So Mr. Tokarski has obtained a PhD from the University Institute of Florence in 1995. He joined the Polish administration and headed a team for coordinating the preparation for accession negotiations. In 2004, he joined the Commission as a cabinet member of the commissioner responsible for regional policy. In 2009, he nominated the head of unit. He was nominated head of unit dealing with economic policy, coordination, and EU funding at DG Mare. In 2012, he became head of defense, aeronautics, and maritime industries at DG Enterprise. And from 2016, Mr. Tokarski has been director in the Directorate F for Industrial Policy Innovation in DG Grow. Mr. Tokarski, many thanks for joining us today. Welcome, and the floor is yours.
Thank you very much. Let me maybe start by rewinding a little bit and putting the current situation in the perspective, and also giving you a little bit the idea of what Commission was trying to achieve in the past and where we start today. And I think in a sense it is a pity that the conference takes place before 24th of November, which is the date of the adoption of our IP action plan, and which would enable me to give you much more detail. But still, I hope that I can give you at least a sort of outline of what the Commission intends to do in the follow-up to the IP action plan. So if you look back, we shall start in 2017, when the Commission published its approach to standard essential patents as a part of broader communication on IPR enforcement. And we took a clearly balanced approach, in line with the title of your conference, incentivizing innovation and contribution of best technology to standardization, while at the same time fostering uptake and access to standardized technology by implementers. And to be more precise, the communication addressed three main fields of concern with respect to SEPs. First, it advocated for more transparency, notably in the context of the declarations of SEPs to standard determining organizations. Second, it gave some signposts for the meaning of fair, reasonable, and non-discriminatory FRAND licensing conditions. And finally, it clarified some aspect of SEP enforcement in line with the Court of Justice decision on Huawei ZTE case. The communication called stakeholders to address identified issues themselves, notably in the form of industry-led, sector-based solutions. And we did indeed see some effort done. A first license was taken from the Avanci licensing platform right after the publication of the communication, with numerous further licensees following since. With the help of Senelec, two papers were developed that provided some suggestions from both sides of the dispute, SEP holders and implementers. However, by now it is clear that no common ground agreeable to all stakeholders was found. To the contrary, we noticed important litigation escalating in Europe, notably in Germany, but also worldwide, and with sometimes diverging directions since the 2017 communication. And this is no good, because the industry needs smooth licensing and valuation solutions. So where we stand now? The position of the Commission has not changed, and we still endorse the guidance provided by 2017 communication. We reiterated this in the roadmap to the IP Action Plan 2020 this summer, where we again set out that we would explore ways to promote more transparency and predictability on licensing of SEPs. We received a number of reactions, including from you, to the roadmap, and I would like to thank you for this. I see that also you ask for more transparency and predictability. But at the same time, we feel a certain sense of urgency. Because if you want European companies to be successful, both as SEP holders and as implementers, notably in the IoT, we need to get it right now. The number of declared SEPs is rising. The latest counts include more than 95,000 declared SEPs for 5G already, from an increasing number of SEP holders, both EU and non-EU. At the same time, the number of individual implementers and of implementing sectors is also steeply rising, and SEPs are not limited to connectivity standards. Now, all these players, old and new, must enter into license agreements, and they have to do so against the backdrop of sometimes contradicting interpretations by different courts around the world. And this results in frictions. These frictions are already very visible in the automotive sector, and this is exactly what we would like to avoid for other sectors, from health to household appliances. There are also more and more SMEs exposed with obvious difficulties in terms of funds and knowledge to cope with SEPs licensing. So we need to have a stable system, one that allows SEP holders to get a fair return on investments, and one that allows implementers to understand and factor in their exposures to SEP licensing fees. And with that, there is a lot at stake: the future of standardization and of Europe's role in standard setting, and the effective rollout of new digital solutions, such as the IoT. So we need to get it right, here and now, in Europe, before others do. We have the biggest internal market in the world. We can set the trend, and we can develop a stable system that can become a blueprint for other jurisdictions. So where to go? Once again, we welcome industry-led solutions, and we are happy to help help and to work with them to spell them out. There is clearly no one-size-fits-all, but industry has to deliver these solutions now. At the same time, we are exploring ways to further increase transparency and predictability, ways to help our industries enter into effective arrangements, whether bilaterally or sectorially. We are currently finalizing a pilot project for SEPs essentiality checks. We did this together with a contractor and a number of European patent offices to better understand how essentiality tests can work and bring added value. We also asked a group of experts to come up with analysis and ideas on SEPs licensing and evaluation. And we are, of course, monitoring the latest developments in Europe and worldwide. So as I mentioned to you in the beginning, we will be publishing our findings and proposed way forward very soon, because the IP Action Plan is expected for 24th November. And we will continue engaging with you and other stakeholders, looking for the balanced solution. Thank you very much for your attention.
Well, thank you very much, Mr. Tokarski, for this intervention. I think I speak for everyone present when I say that we very much appreciate the attention and the care which the Commission gives to this topic. We look forward to seeing how the Commission develops this space in the future. And there's much to reflect on and think about. We're now going to move to our first panel discussion. As mentioned at the beginning of the event, please submit your questions for the panels in the Q&A or the chat box. We will collate these and give these to the chair, who will then ask the questions of the panelists in the Q&A section. So to get us underway, I will now pass the floor to the chair of our first panel, Rebecca Porath from Intel. Rebecca is the Director of Standards and IP Policy in Intel's Government, Markets and Trade Organization. She has a long-standing experience on standards and IP matters. So I think we're in very safe hands for this panel. Rebecca, I hand it over to you, please.
Thank you for the introduction, and good afternoon, ladies and gentlemen. It is my pleasure to lead you through our panel on use-based licensing today. The question on whether use-based licensing is or is not a hindrance to innovation is a highly topical one. Fundamentally, that question boils down to how standards essential patents should be valued within a broader innovation ecosystem context. Today's innovation ecosystems are highly complex. Modern high-tech products do not only involve many standards and thus many SEPs, they also involve lots of other standards-independent innovation from many different parties, which are brought together into highly integrated multifunctional devices. Just think of how your smartphone combines functionalities for which you used to have separate dedicated devices, cameras, audio players, GPS devices, flashlights, etc. There's ongoing innovation in each of those parts, as there is innovation in bringing all of them together in single, small, handheld devices. Industry and its policymakers recognize how important standards are to enable this sort of innovation. But standards can also include innovation themselves, and that includes innovations through patented technologies. The question then is how those standards essential patents should be valued to ensure that there is a fair balance of rewards and incentives for all the different contributors to innovation. I'm very happy that we have an excellent panel of distinguished speakers to look at this question from different angles, from an economic perspective, from a legal perspective, and from an industry perspective. I will now introduce each of the speakers very briefly. Within the time we have available, I can't do justice completely to them, so I do invite you to read their full biographies in the booklet provided for this conference. I'll start with Professor Dr. Joachim Henkel. Professor Henkel is Professor of Technology and Innovation Management and the Vice Dean of Research at the Technical University of Munich School of Management. His research focuses on patent management, standards, digitalization, technology acquisitions, open innovation, and value capture. His work has been published in numerous respected journals, and he has regularly advised firms in the ICT industries. Next, I would like to introduce Ms. Sylvie Voulet. Sylvie Voulet is General Counsel at Airties, a technology company headquartered in Istanbul with a worldwide presence. Airties has been producing Wi-Fi technologies for more than 15 years and holds more than 30 Wi-Fi related patents. Before joining Airties, Ms. Voulet served in different international legal roles as an in-house legal counsel or attorney. For several years now, Ms. Voulet has been deeply involved in cloud, data privacy, and standards essential patent licensing issues. Her colleague, Koen van Oost, is the staff systems architect at Airties. He works in Airties research department with the chief technology officer, advancing their smart managed Wi-Fi vision. He helps define the product strategy by advising his team on the evolution of standards, emerging technologies, and how they impact Wi-Fi quality and experience. Mr. van Oost holds a Master of Science degree in electronics and has occupied various positions in the telecoms industry over the past 20 years. I next turn to Dr. Roya Gafele. Dr. Gafele is a director of Oxfirst, an award-winning intellectual property law and economics consultancy. She has held academic positions in international political economy and business with Oxford University since 2008, and was also a tenured lecturer in IP law with Edinburgh University. Dr. Gafele specializes in IP valuation, IP-driven growth, IP audits, and IP and open innovation. Last but certainly not least, Sabine Ager. She's partner at the law firm Hoyengrog Moniger and has dedicated herself to patent litigation for the last 20 years. Ms. Ager has developed particular expertise, among many other things, in issues related to standards essential patents in the areas of electronics and telecommunications. She is a prominent member of many professional, international and national associations, a regular speaker at conferences, and a lecturer on patent litigation for various university courses. We will start our panel with a short impulse statement from each of our panelists and thereafter enter into a discussion. The questions that you will be asking, and I invite you to start putting your questions into the questions and answer box while we go, will form the basis for this discussions. And if there are no questions, I will have a few questions to get you started. But yeah, we'll turn to that after the impulse statements, and I hope that we can deal with as many of your questions as we can. And with that, I'd like to give the floor to Professor Henkel as our first speaker.
Thank you very much, Rebecca, for the kind introduction, and thank you to the organizers for having me. Share my screen. You should see my screen now. If you don't, please protest. I will speak about the effects on innovation and entrepreneurship of patent licensing in the IoT, and in particular on how it is done. I should mention that this is based on scholarly research. It is not funded by any third party. Let me start by stating something obvious, namely that the IoT is a hotbed for innovation and entrepreneurship. This neat device here is from Agrilution, a Munich-based company. It's called the Plant Cube, and allows you to grow fresh salad in your kitchen. A challenge for this company and many others is SEP licensing, as we know. This is why we are here. Depending on the standard you use, there are easily more than 10,000 SEPs, and that is SEP families involved. And the question that is obviously important is how to ensure fair and consistent licensing. That means fair and consistent for both sides, really. In other industries, this is solved in a simple way. Inputs are by default fully licensed. This is from the US Uniform Commercial Code, and there it says, normally, goods shall be delivered free of the rightful claim of any third person by way of infringement or the like. So that is kind of the base case. However, in IoT, SEP holders push for device-level licensing. And the question is, what are implications for device makers? And I want to make explicit, it is not about the big cases that appear in the news, especially Nokia, Daimler. It's more really about the smaller innovative firms, the startups. To find out, I conducted interviews because most of the literature on that topic is largely theoretical, or at best based on anecdotal evidence. A sort of legal discussion, which is important. However, in the end, the question is, how do we promote innovation and entrepreneurship? And if needed, we need to adapt the law. So I had 11 hours of interviews with 17 people from 11 firms, among them 6 startups, but also 3 large implementers and 2 large SAP owners. And I'm very grateful to all interviewers for their time. Outcomes. The way that SAP licensing in the IoT works today creates impediments for innovators and entrepreneurs. First of all, several of the firms I spoke with had been contacted by SAP holders with a request for taking a license, even though these firms were really small. And that puts them in a very difficult situation. They essentially felt lost, receiving a letter listing 20 patents they could not interpret and saying, we would like money. They lacked the technical knowledge to address if really infringement happened. And in the IoT space, is not every implementation is the same, different from a DVD player, by the way. That is very important here. They had no idea if it's essential, and importantly, what share in the overall standard a certain patent holder had. They lacked the legal competence to address these questions. They also had no idea about SEP licensors. So as we know, the landscape is highly fragmented, and despite some patent pools, there's still easily tens or probably more than 100 people who could, in principle, call and send a letter and say, please take a license. It's totally legal. It's just that it is impossible to handle for a small young firm, and even for a mid-sized or larger firm. They also had no idea what FRAND actually means in that context. And small young firms are typically resource constrained, and so they lack the time to deal with that. They need to care about product development and customers. Those startups, as a first step, of course, they faced an NDA. and also other speakers will address that, talk about transparency. Signing that means you're not even allowed to speak with your supplier about these patents, which puts them in an even more difficult position. They fear an unknown number of further SEP holders might approach them. They suffer legal and cost uncertainty, which makes price planning, etc., very difficult. And they were kind of puzzled because they thought, hey, we can buy other input goods fully licensed. Why can't we buy this either Wi-Fi or 4G, etc. chip fully licensed? Here's a quote: "I do not buy an ARM license when I buy a processor, but rather a processor with a license included." And partly, and here's a worrying fact, considered using older standards instead of, for example, 4G, because it appears like those are more likely licensed upstream. Here's from one interview where a person said, "This is clearly a problem because it is not regulated. And at the moment, we cannot solve this problem in advance. Especially as a small buyer, we are at the mercy of the patent owners. We cannot fully invest into the technology today without considering that and checking, okay, what is the risk that we run and how much will we have to pay later for individual devices and how can we pass this on to the customer?" So high uncertainty in a very bad position. We have no financial control at all. I should add that especially for young firms seeking financing and maybe seeking an acquisition or IPO, the threat of a lawsuit by one of these tens or even hundreds of SEP holders might be very, very harmful. On a broader level, on an economy-wide level, we have much higher transaction costs the further downstream we license. On the one hand, there's this information asymmetry, which invites opportunistic behavior. As we just saw, those implementers are not in a position to discuss on eye level with SEP holders. But just by the numbers, there are maybe a dozen or maybe a few more baseband chip makers worldwide versus, we don't know, thousands, maybe tens of thousands of IoT device makers. And just the sheer number of contracts multiplied by the number of licensors is just ridiculously large compared to licensing upstream. And this is also part of the EU guideline to minimize transaction cost of SEP licensing. I suspect it will lead, or does already lead, to slower adoption of new IoT technology. There's an impediment to downstream innovation to license at the device level. It also will lead to inconsistent licensing. Some will take a license, others won't. Some will enforce it, some patent holders, others won't. And imagine that every IP holder of every IP in a device starts doing that. Like every holder of DDR RAM patents, they could do the same, or IP cores. That would be quite a mess. Suggested solutions. I don't see any other way than licensing upstream, be it NAD or chip level. Most SEPs are implemented there. One can, of course, adjust the royalty rate to the royalty base. One has to, of course, to make sure SEP owners get a return. One can do price differentiation also on the component level, with the advantage that it captures actually differences in the performance of implementation rather than other product features. And thinking about how many cellular IoT connections we are projected to have, Ericsson projected 5 billion by 25. Even with a relatively low royalty, SEP holders should get a quite decent return. And transparency, SEP holders need to announce royalties early and publicly to avoid cost uncertainty. Thank you very much.
Thank you very much, Joachim. I'll next give the floor to Sylvie and Koen. I don't know who wants to go first, but it's airtight. You have to unmute yourself, Sylvie.
Okay. That's about. I'm a bit old school. Huh? Face to face was was better.
Yeah, so, those were the days.
Thank you, Rebecca. Thanks for giving the opportunity to give a testimony as an SME under the SEP ecosystem. I must confess that I became, when I became maybe an expert, I was not 9 years ago, and I was not really intending to be an expert, but as the single legal person of an SME, a device manufacturer, I would say I had all chances to go through SEP knowledge. I would say 9 years ago, when I received the first letter, I always say that it's a love letter, but truly I was a bit running like a chicken no head, because it was very different from whatever claim I had to go through. I was already an IP lawyer. I would say it was a bit like binary. You would want to be licensed in technology. You will go negotiate and get this technology, but you will know which technology, and you would, if you were, let's say, infringing, you would know that you were infringing. With SEP, it's completely different context, and I would say, so I would try not to go through all the issues we have as an SME, but we have a number. So the first thing is that as an SME, we don't have the opportunity to start legal proceedings or go to court or arbitration actions. We don't have the budget. We don't have the financial financials to go through proceedings. So we have to deal with what we have. And unfortunately, I was very, I would say I was hoping a lot when we received the communication, the European communication. I was thinking that things would be improving, because we received a number of letters and FRAND was only formal, but not in reality. Today, unfortunately, I'm still facing a number of issues, and some of the issues have not improved, are really even getting worse. So I would just like go through, let's say, the issues with transparency and predictability. The fact that as an SME, because there is a power balance which is unfortunately not in our favor, it's a bit a twilight zone. We don't know that we infringe most of the time. We have, I would love to have a list of SEP and understand when you get a letter, you have to sign an NDA. The terms of the NDA are generally so strict that you cannot even have discussions. And for an SME, it's important that we can exchange with our customers or channel partners. So transparency is not there yet. We don't have information, we don't understand. You receive a list, you don't have claim shards, but you receive a list. Some of the patents are still invalid, and most of the patents are NEPs and not SEPs. And so it's still really difficult to understand. So there is an issue with transparency. Predictability, it's another issue. I would say problem is that as a device manufacturer, we are squeezed in the middle. We are between chipset and customers. Our customers are operators. And when you sign with an operator, you sign a long-term contract. And of course, the operator will say, okay, you provide us with technology, which is fully licensed. You will not come back tomorrow or the day after tomorrow with a request to change the prices, because you have discovered that you have an SEP issue. So you discovered that your price is no longer applicable. So you have this lack of predictability, which is an issue. But moreover, on the indemnification side, the fact that we cannot get any indemnity from the chipset vendors, and we have full indemnification on our customer and channel partner side, is representing really a new challenge. And the new challenge is even worse now, because I was used to have like patent indemnification, which would cover any patent. But now we get more and more specific wording about indemnification in case of SEP. So that does mean that first, it's a very different landscape. And second, there is an issue for our customers, and our customers are trying to cover this lack of predictability, and they want to be fully indemnified, but not only. Now, what they would like is that if we are not fast enough, if we don't close negotiations fast enough with SCP holder, they would like to, they put the terms that they will take over and negotiate. So we would end up with paying for the past and for the future license fees we have not negotiated. So that's the legal background. I would like to give more opportunity to Koen, who is our engineering person, so that he can explain his view, what is a claim, SEP claim for engineering person. Thank you for listening to me.
Okay, thank you, Sylvie. So, yeah, good afternoon, everybody. As mentioned in the introduction already, I'm one of the staff architects at Airties, mainly involved in technology assessment and standardization as such. And I would like to share my view on SEPs, or let's say the hindrance or the malpractice around SEPs, basically, not necessarily from an economical point of view, but from an engineering standpoint. Because as an engineer, of course, you like to innovate, you like to create products that are deployed in the broadest sense of the scope, basically. As such, you leverage on standards, because standards are getting you somewhere. You look at Wi-Fi, if there is a standard, devices intercommunicate with each other, so you need to use a standard. It's useless to start doing things on your own, especially as an SME, because you're getting nowhere. So standards, of course, are defined by multitude of people, and in general by large corporations. Yes, as an SME, we do have standards, patents in standards as well, and we try to contribute. But the reality is that the balance between SMEs and large corporations in terms of standardization is never going to be in the SME's favor. So the SEP itself is valuable because it earns back all the effort you spent on developing a standard, so that's right. But as an SME, basically, you have to use whatever is there, and there is really no other choice. So you buy a chip, you don't buy a bunch of standards, you buy a chipset and you make a Wi-Fi product, for example. So as such, it's not really an interesting practice that 30% or more of your engineering budget has to go to infringement analysis or a claimed infringement analysis, because it's not the infringement analysis per se, it's typically non-participating entities that burden you or dump a huge amount of acclaimed SEPs on your account, and you need to analyze them on a daily, weekly, monthly basis, only to find out that maybe one of the whole bunch is potentially infringing, or interesting, to put it like that. So you are spending lots and lots of resources, which you don't have as an SME, because literally we only have a handful of people able to deal with that. So you're losing valuable resources on that process alone. And yeah, this shouldn't be the case. You should not be bothered by let's say being buried under tons of acclaimed infringements. You should have a clear identification of, this is a standard, these SEPs relate to a standard. By the way, lots of standardization bodies do have a call for IPR before going to ratification. So there should be a way to accomplish that. As such, you can do an assessment of your, let's say, buy or make kind of deal when you're deciding on how to go forward with innovation with the product, and also how to step into a market. If you intend to go into a market which is already heavily contested by a huge amount of SEPs, well, as an SME, it's sometimes even pointless, because you know you will get hit a lot, and it's maybe not worth the effort. So you need a clear identification of what is already at stake, and not, as we experience it today, you start building a product, and years after the product launch, you suddenly get a ton of acclaimed infringements that you need to analyze. And from that point onwards, let's say the amount of work keeps building onwards, because every new standard release gets or let's say picks up 5 years after the release, and you get another bunch of potentially infringing statements, let's say. I think I also heard the statement that a lot of these MPEs are not even aware of the technological aspect. So they just send you a bunch of stuff, And that is the reality. You have poor claim chart proof. You have very, very poor, I would say, written agreement on what is the exact problem that you would be infringing on. As such, the whole burden of proof rests on the implementer, being the SME, and not on the person that is trying to let's say prove your point or prove his point that you are infringing one of the SEPs. And for me, I mean, and I think I speak for a lot of the SME companies, even startup companies that are way smaller, it's just malpractice. You should be focusing on product design and technology research, and not on studying vague, let's say, acclaimed infringement cases that people try to bury you with as a potentially even strategic, I would say, move to limit the SME from moving forward. So that's my view as an engineering, say, head or staff co-worker at Airties. Thank you for listening.
Thank you very much, Sylvie and Koen, for giving us this account from real life experience. Our next speaker will be Roya. Roya, you will have to unmute yourself.
Yes, I already have done that. So
Super.
thank you very much for inviting me to present today. I'm profoundly honored and I appreciate that opportunity. I also would like to thank the European Parliament for enabling this important discussion, which has proven more than anything else of urgency, because we clearly need more input and more stakeholders in the European Union to get involved in this debate. And I think this is a very important first step in that direction, and I encourage the European Parliament to take further steps in that way and to do more to protect the interests of European citizens. I'm Austrian. I currently live in London, and it feels kind of like being the English patient in this movie during World War II. I have heard a lot today about what is good for business. I haven't heard a single word what is good for Europeans, for us, for the people. And I believe that in European policy formulation, we need to put the needs of people first. After all, this is what Europe is composed of. In that respect, I think it's very important to keep the needs of the consumer in mind rather than the needs of business only. And we need to achieve a balance not only between various types of businesses who have different business models, but there needs to be also an inherent social contract that is preserved between business and citizens in the form of consumers. I'm very concerned that this aspect has not been taken under consideration, which could lead to the harm of European citizens. In particular, I'm worried that under some considerations or approaches taken, which may be biased towards one side of the debate, access to technology may be hampered, and affordability of important technology, which we all enjoy, will be difficult for people. We won't have the money to buy it, and this is not okay. And I'm very disappointed to see that in all of these debates, associations which represent the needs of the people have been more or less absent, and that the voice of SMEs has also been inadequately reflected. I think it is very important to keep in mind that we formulate bottom-up policies rather than top-down policies. I have no doubt that the CEOs and mighty and powerful of this world have no problem of attending unpaid meetings and unpaid expert groups. It is not a possibility for SMEs. It is not a possibility for normal, ordinary citizens to do that. In that respect, I also think we need to make sure that in whatever we are doing in this debate, we are assuring the public interest, the intérêt public of various European nations, be they small or big in size. It is not that every single European country has corporations that own important stacks of standard essential patents. My own country, Austria, does not have any standard essential patents, and I am very concerned that we succeed as Europe to assure that the needs of small European countries are just as well reflected in European Union policy formulation as those of the big ones. We cannot afford that we have a Europe that functions at different speed levels. We need to assure a Europe where the small countries and the large countries, the countries that are home to SEPs, standard essential patent owners, and those who are not, are all can see themselves in European Union policy formulation. And this, I think, are two very important goals in no matter what we are doing. And in all of this debate, I have not heard a single word about these issues. And I believe it is up to Parliament to bring these topics back to the debate. The third issue of this overarching framework, which we will need to think of how to keep it in mind, is that the way policy formulation functions assures gender balance, gives the same opportunities to men and women, to rich and poor, to young and old, to have their voices heard. This is one of a very fundamental principle of democracy and of democratic formulation. And we need to bring this principle back to the debate of standard essential patents. I must really repeat, it cannot be that this is only a debate which is driven by insiders, by companies who have become very rich, either because they're on one side of the debate or the other. We cannot have policy formulation driven just by the elites. This is for us, the people, and the people need to come first. With these three big issues, which I'm currently not seeing reflected in the debate, and which I once again repeat, this is the job of European Parliament, and I'm very happy and I'll be very honored to support the Parliament in these important efforts as Austrian, as European citizen, and as a woman.
Thank you very much, Roya. Then we turn to Sabine Ager to provide us a perspective on these various matters from a legal point of view. Sabine, the floor is yours.
Yes, thank you, Rebecca. I think what I wanted to do at this stage, because I'm the litigator, I would like to send you I would say, an optimistic message saying, the courts will help you find your way. I'm afraid that's not the case. Clearly not the case. I mean, I would even say that currently, the trend, there is always a trend which may turn towards the patent holder and at some stage the implementer. But my overall impression currently is that, at least in Europe, I think the courts, and that's, I think, mostly because the main jurisdiction issuing decisions currently are Germany on one hand and the UK on the other hand. In the UK, all of you have heard about, the Supreme Court decision in the Unwired Planet and Conversion case. And I think that's the optimistic message, maybe. And, it relates to what Roya just said. At least we have one decision in the Unwired Planet case, which from a court which is prepared to make a decision on what front maybe, with, I would say, indications on, what could be a right calculation. And that's a mix of comparable licenses and top-down approach that Roya mentioned. And I confirm, to the best of my knowledge, we don't have in Europe, and there's, I think, nowhere in the world, any decision saying that a use-based license may be the right one. For Germany, I would say that currently, clearly the trend is in favor of the patent holder. What's slightly concerning, I think, is that, there have been a number of decisions recently showing that even the German courts are departing from, the requirements and guidance which was provided by the Court of the ECJ or CJEU, so Court of Justice of the European Union, in the Huawei ZTE case, which, you know, struck a balance on, you know, the requirement and obligations from the patent holder and the implementers. And so, you know, currently there have been a number of decisions in Germany in which an injunction has been granted against, you know, Daimler. So, of course, you know, as Roya said, most of the decisions currently, and I think Kuhn said it as well, are between, you know, big companies, big corporations, or at least patent holders focusing on defendants, which are big ones. But at least the message which is sent is that as an SEP holder, you can go against a, you know, the device maker, and you can even be granted an injunction with consequences which are, of course, you know, going very far. When you have a look to what happens outside of Europe, I would say in the US, we don't have any clear message. Of course, you know, we are, I would say, finishing a time period where, you know, even the two competition authorities, the FTC on one side and the Department of Justice on the other side, didn't have exactly the same views on, you know, what is FRAND and whether they should have a, I would say, role in the discussions and, you know, the decisions on what should be FRAND and what should be the behavior of SEP holders. So I think we won't be having any guidance from the US, at least in the coming months. What may be interesting to monitor still will be the decision that Judge Selna will be giving in a case in which you've had a first decision on valuation of SEPs, which is the case between Ericsson and TCL. The first decision of Judge Selna was reversed by the Federal Circuit, but it's been remanded before the same judge for the decision to be made by a jury. And I think that would be interesting because, you know, it's not exactly the same calculation, but at least in the first decision, we've had, you know, the application of the top-down approach and comparable licenses as well. So I think at least it's a case that should be looked at, and I'm sure that will be interesting as well. And to finish my overview, I think it's also interesting to have a view of what Chinese courts are doing. Because of course, after the you know, Supreme Court decision in the UK and in the Enwired and Conversant case, we also turned to Chinese and tried to understand whether at some stage they would be willing as well to provide decision on what could be, you know, a proper FRAND license rate, even for a large portfolio, including non-Chinese patents. So far, the Chinese court have refused to do so, but we hear from practitioners that you know, they've given signs currently that you know, they may be willing to do that at some stage and in the coming future. And I think that's interesting because some of the, I would say, upstream players and you know, some of the suppliers even of communication module to Daimler and to the automotive industry are Chinese. So, you know, we may think that in the future, even Chinese court may have a role in trying to, I would say, clarify what could be the value of a patent portfolio with all the caveat that you may think about, you know, what a Chinese court may decide, you know, upon request of a Chinese manufacturer. So I'm afraid my conclusion, and again, that's not very optimistic, is that, you know, it's rather chaotic for defendant currently. And I think it really shows that we should be having, and I'm hoping that at least, you know, these communication coming from the Commission, I'm hoping will give some, you know, long felt guidance. And, you know, I'm sure it will be addressed during the second panel, but we're also hoping that there will be an additional referral, maybe by a Düsseldorf court, on the level of licensing. And we know that will take time to get the decision from the Court of Justice of the European Union, but I think if this referral go his way, we may have additional relevant guidance as well. So let's see what happens from Düsseldorf as well.
Thank you very much, Sabine, and thank you to all the panelists. Wow. We live in challenging and interesting times. That's would be my very short summary. We have time for questions as we plan to have. Let me just see. So there is a question which is to all panelists. Is an SEP justified to enforce an injunction stopping production of automobiles due to a single chip infringing a single SEP? How do you justify permitting SEP owners to refuse to directly license the entire supply chain? Who wants to give it a start? Sabine, you're laughing, so you get the first.
I am. I think it's the very question, and of course, an injunction has been granted by, you know, the Landgericht Munich, so the Regional Court of Munich recently, and several of them have been granted, in fact. And you know, I think it really goes to how the German system is working, and we know it's a system which is clearly pro. Claimant and pro-patent holder with a very strong, you know, I would say injunction in place, with you know, a judge who, when granting the injunction, has even not reviewed the validity of the patent, which to me is, you know, a flaw of the system, as we all know. So to reply to the question, I think it's justification is difficult to see. I do agree.
Okay. Any other views?
May I add briefly from an economics perspective?
Yeah.
I think the idea of granting an injunction based on a single patent is really more suited for the light bulb than for a complex product embodying, I mean, even for the communication standards. Well, I mean, altogether 100,000 patents in a single country, that is just not appropriate. And I mean, courts should in the end sit down and come up with a number. That would be, but they usually don't like that, of course. But that would be a better way out.
Okay, thank you.
Maybe Rebecca, if you allow me just an additional word to say that, you know, of course, you know, an injunction should be, I would say, the relief for a patent which is infringed. And we have to bear in mind that, you know, the entire system is only balanced if the patent holder has, you know, an available relief to have the infringement, I would say, sanctioned. But to reply to your question, to the question again, I think, you know, even if you go for an injunction, you could go to a relief which is different, which would be you have a certain amount of time to change your product, to buy another cheap. And so, you know, having the injunction really prevented the sale of the car itself seems, you know, disproportionate at least.
Mm-hmm. I mean, I'm also reminded of the solution that Joachim proposed, namely that ideally licensing would take place at the, well, in case of communication technologies, at the network at access device level. I'll just squeeze in a question of my own. If you say that would be the ideal solution, how would you see that solution implemented? Obviously, it's not happening by itself.
It's a good question.
So what would need to happen?
Actually, it does happen. It's not that all SEP holders exclusively license implementers. Some do, and actually some, I mean, it's public on the website, uBlocks actually offers to, if implementers get approached for royalties, then they offer to do the negotiations. So it's not a fully fledged guarantee, but there's diversity. It is being done. It is not impossible. The argument is and that answers partly the first question here, why do you justify SEP owners to refuse to directly license? The argument is price differentiation, that you can charge more for a larger product than for a smaller. And there's some justification in that, but it has to be balanced against the huge complication that you have, that both Koen and Sylvie and also I talked about, with the transaction cost that comes along with that. So I think that is perfectly doable. Just license them. Of course, they're not that few. There would be even fewer chip makers, baseband processor makers, but still fewer NID makers than IoT device makers. So that could be done, I guess.
Okay, thank you. I'll look out there. Actually, now I feel sorry for having given you the floor, because there is a question directly to you as well, and I want the others to speak as well, but I'll start with this one because I have it right here now. So you're being thanked for your good presentation, and I think just, yes, also on my behalf. The question is, could you give your definition of startup and SMEs? Does it happen frequently in your research that patent holders target SMEs and startups? This does not sound like an economically sound choice by patent holders and might be a very infrequent case in the real world. Transaction costs would often be higher than the expected income.
Yeah, thank you. Very good question. A couple of answers. So among the 6 ones that in the sample so far, and it's ongoing research, 2 of them had been approached and 1 of them by 3 different licensors. And also bear in mind, I mean, especially NPEs have in the past approached even coffee shops for getting a license. It's more than the nuisance litigation, but it happens. The other point is, those that were not approached, they were still under threat because they didn't know they might get a letter tomorrow. And also from the side of the patent owners, there's this argument of building a reputation and making sure everybody takes a license without complaining a lot. So even if it doesn't pay off in the individual case, it might pay off in the long run to build that reputation. And also, most of the arguments I gave, they apply equally actually to Daimler as they apply to any of the small firms, because they just don't understand the technology. The difference is just that Daimler has the financial strength to get legal support and have people explain, lawyers who understand, and technical people who understand technology. But this is usually not all their business. For the small firms, it's even worse because of resource constraints. But otherwise, it also applies to, well, not only startups, but also larger firms. By the way, in my sample, they were less than 10 years old. That was my definition here. But it also applies if you are 50 years old and have 100 million sales. You still don't understand SMEs, sorry, SEPs. So it is not only to startups. Thanks for that clarifying question.
Then another question, and I'm posing this now. You said, and this also came across also in the testimony from Sylvie and Koen, that it's really, really hard for smaller companies to understand SEPs, to even know whether they're infringing or not infringing. what is the fundamental difference here between SEPs and non-SEPs? Because I would imagine also that, well, I talked initially when I introduced the panel about the many patents on many different functionalities that you nowadays typically have in complex, highly integrated products. I would imagine also for the non-SEPs, it's a challenge to understand what you might be infringing, but hey, you may still be, even if it's a challenge and even if it's difficult, one could say well, why wouldn't you be expected to, confront that challenge? Because tomorrow the patent holder that may come to you and assert his patent against you may be an SEP holder, but he may also not be. It may also be a non-SEP. So what is the fundamental difference here between the SEP and the non-SEP in terms of exposure, especially for small and medium-sized firms?
Well, if I may,
Yes.
the significance for an SEP is because it's linked to a standard, and by such it's kind of implicitly infringed, because they say you implement a standard. We believe we have a couple of SEPs and we don't even care about the NEPs, because the SEPs are the money makers, because the standard is enforcing interoperability and you need to use it. And then on a later course, we'll come back with NEPs, because we also have a bunch of those, and we'll try to sort that out. Because, I mean, they are, from a patent holder, equally valuable. But of course, if you manage to score an SEP in a very popular communication standard or whatever, yeah, then the value goes up, and all, because the infringement domain goes up for sure. And I think that's the major takeaway from these, I would say, large patent portfolios that they throw at you. They simply don't nuance them correctly. They just say they're all SEP and they are linked to your business, which is Wi-Fi. Done. And now the ball is in your camp and you need to figure it out. That's what the value is, or the acclaimed value, because I mean, I think they're equally valuable if you compare NEPs with SEPs, but the domain in which they are applicable is simply much larger if you're talking about a standard essential patent, because they link to your business directly, whereas an NEP may link to a certain niche feature that you are using, and potentially, of course, you infringe, but you can work around it. Whereas if somebody attacks on, for instance, the framing construction of a telecom standard, you cannot get around it unless you just step out of the standard usage. And that's a major problem, of course.
Thank you. Does anybody else want to chip in as well? If not, I go to the next question.
May I briefly? Sorry, even though I have said already. So totally agree. One more point is that, as I said, usually for other patents, it is the supplier that takes care of those. So you could usually send those demands to other suppliers, and who then understand what they were doing. So they know their product, they know if a claim is justified or not. Well, that is a big difference. The licensing level again.
Okay. Now, yes, please.
Rebecca, I just wanted to add that when you are, for example, on a set-top box, and it's purely non-technical what I'm going to say, but we know which technology we are going to use and which technology we need, even if it's purely codecs. So if we have a number of technology to be into the device, and that's the difference. We know, so we negotiate, we try to negotiate, but at least we know if we don't take this technology, we know that we infringe. Again, with SEPs, we don't know. That's fine.
Why don't you know for SEPs, but know for other patents?
Sorry, why don't we? Sorry.
You said for SEPs, you don't know whether you infringe. For other patents, you always do.
In fact, with SEPs, first, it's almost, Koen explained already, when we get a claim, it's already difficult to determine whether it's an SEP or not. There is a mix. The second problem is that you might infringe, you don't know if you will not pay for one SEP and have to repay through NPE, not a second time, but it's difficult to determine. It's highly technical, and Koen could say that better than me, but it takes ages to understand just if we do infringe, as he explained. So it's totally different. It's not suppliers looking for technology. It comes once you have already developed your device.
Okay, thank you for that explanation. I have a question that is directed at Roya and Joachim. And Roya hasn't said so much in the discussion yet, so I will ask her first. Roya, what data, empirical evidence, and methods should be used to estimate whether SEP holders receive fair and reasonable return in practice? Also noting that according to the European Commission communication on SEPs, determining a FRAND value should require taking into account the present value added of the patented technology.
This is a question on which I spent nearly 2 years of research on. I don't think I can give all of this back in a few minutes. But whoever wants to know more, please get in touch. I'm happy to discuss this further bilaterally. There are a couple of methods that have been internationally recognized by courts, and I think that is a helpful starting point. And we are also seeing that courts in Japan and China and the United Kingdom and the United States, that there's a certain consolidation, in my opinion, of terms of methods that courts tend to recognize. And in my view, the most recognized methods by courts in that debate are the top-down approach and the comparable licenses approach. And these methods have not been, these are not necessarily some pure separate methods. They have also been used in combination, or they have supplemented each other, or you took an element from that approach and put it in that one and make a mix and match. These are not pure separation methods. The method proposed in the communication from the European Commission, the present value-added approach, I believe is a recommendation that has been made. It is hinged on a discounted cash flow approach, where you essentially are looking at the dynamic model, how technology is going to evolve over time, what risks are going to be there in terms of legal risks, economic risks, patent risks demonstrated by itself, and you try to model the risk rates in the valuation. These are mainstream financial methods of how the financial community is assessing the value of corporations, essentially. However, what was being tried with the present value-added method is to combine this with the question of patents and standards, and that's the exciting thing about it and the novelty. And it is important to say that this method can be used at any level in the value chain and can be based on at the chip level, at the intermediate level, at the end product level. It is not use-based licensing. That is really important to differentiate. And it is not just through hedonic, it has nothing to do with hedonic price regressions at all. Or with other methods that have been employed in that context. I must really make that clear. And it would be extremely unfortunate if the audience were to confuse hedonic price regressions and methods that are based on interviewing consumers on what they think about this technology with the present value-added method, which is actually quite an original idea to model the value of technology and the contribution, the incremental value that the patents have to the technology, not the end product per se. This is a confusion if this is being mixed around with. That's really important to keep this in mind. I'm not saying it's not possible to use the end product, but it is not that this is the only way of doing this. This can be used at any level. it is not discriminatory in that sense. But I think Joachim is kind of like, I need to say something too, so go ahead, please.
Do go ahead, Joachim, if you want to.
Yeah. Well, no, I was totally patient. Yeah, it's a very important question, how to do it really. I would like to remind us of another perspective in the EU guidelines on the application of Article 101. It also says that one method could be to refer to an ex-ante situation, to a typically, unfortunately, hypothetical situation where two technological solutions were competing on the market before one of them then eventually prevails and becomes the standard. And in that situation, the guidelines suggest to look at the royalties that were charged before one of them finally became the standard. And if you look at that and then you ask yourself, so what is actually a fair return on the investment? Then maybe the question is not so much what each individual implementer or individual device or chipset, etc., should pay, what royalties they should pay, but rather how much royalties the standard developers capture altogether. And if that is they should get a decent return and risk adjusted. Of course, everything that is very important to keep innovation on that level alive. And it is very expensive. There's no doubt at all. However, that would be an actually super interesting number to see because they would, in a hypothetical ex-ante situation, certainly not come up with royalties that would allow them to get whatever, even a multiple of their investments back. And given the projected numbers we have for IoT, plus of course smartphones, they also implement 5G. Just a reminder, we're talking about many billions of devices. Then actually you don't maybe need to price differentiate on the level of each device in order to get a really nice return to the standard developers, which they should have. So that is one addition to that question. Thank you.
Thank you very much. I have been notified, and of course I should have noticed myself, that we are running out of time. So I'm afraid we have not been able to answer all the questions that have been posed, but I hope and think that we will find an opportunity to do so offline. I do hope that I also realize, and I hope the expectation wasn't there that our panel was going to answer all the questions. We didn't, but I hope we managed to shed light from different perspectives on the nature of the challenges, on the root causes of the challenges, and also on some approaches that could be used to start addressing them. So thank you very, very much for the panelists, and thank you for the audience for interacting with us. And I'll hand back to Alex.
Thank you very much, Rebecca. Thank you very much also to the panelists. A very holistic panel and a really robust discussion. So I'm very happy with that. We're now going to move to the second panel, but in order to do so, we're just going to take a 60-second break while we rearrange the panels. So please just stay on the line while we take care of that. Excellent. I think we have all our panelists ready to go. So we're going to start now our second panel on the anti-competitive effects of refusal to licensing. As with the first panel, we have an excellent group of speakers for you today. And I think that we have almost the entire value chain represented. So I'm now going to hand over to the Innovators Network Fellow, Jim Beveridge, who's going to moderate this panel. Thank you, Jim. Please take it away.
Okay. Thanks, Alex. So good afternoon, ladies and gentlemen, and welcome to the second panel of this afternoon. The panel session is scheduled for some 50 minutes, and initially we'll have an opening statement from each of the panelists. Hold on a second. And this will be followed by a panel discussion, which will in turn be followed by questions from the audience. So I encourage you at this point, if you've got questions, then use the Zoom interface and do send your questions through to Alex. We'll try our best to get through them. But allow me to start by saying a few words to set the scene at the 10,000 meter level, and then we'll zoom down into the discussion in the panel. So right now we find ourselves in Europe, and Europe really is a continent buffeted by the perfect storm of COVID, with a bit of Brexit added in for good measure. Europe's political, legal and industrial institutions are galvanized in their quest to both navigate their way out of the storm, whilst using the disruption as an opportunity to encourage new growth, set up new structures and prepare for a post-COVID, geopolitically complex world. And at the very top of the EU's economic policies sits the SME community. SMEs represent some 99% of the businesses in Europe and account for more than half of Europe's GDP, so they're important. So to drive the economic recovery, SMEs will need the coordinated support of Europe's institutions. The European Commission has a goal of upskilling and up-financing the EU SME sector en masse, reducing its barriers to growth and encouraging the sector to play a pivotal role within the digital transformation of Europe. Arguably, Europe has to date been at the forefront of the global digital communications transformation through its prowess in setting digital cellular communication standards via the European Telecommunications Standards Institute, ETSI, and also in the digital television standards domain through the Digital Video Broadcasting Project, also known as the DVB. So the question is, how can Europe's powerful digital communication strategic standard setting assets be used to support and promote its SME community in a post-COVID world? EU SMEs seeking to prosper in an AI, 5G, IoT world will need to be standards IP savvy, understand the importance of standard essential patents, become efficient at generating IP, and gain unrestricted, timely access to IP at the right price. The economic opportunity is clear. It's to accelerate the transformation of vertical markets, where SMEs with industry and regional know-how can help digitally transform indigenous vertical industries, combining their communications expertise with knowledge of the necessary vertical applications. In summary, Europe has world-class standard-setting institutions. The question is, can these institutions adapt to the ever-increasing speed of technological change? Can the legal systems underpinning these standard institutions react in a way that provides clarity and certainty to the companies seeking to implement these standards? It is with this background in mind that we come to our panel session this afternoon. Our brief is to shine a light on some of the barriers the SME community faces, the history of refusal to license, including the contextual aspects of refusal to license in the past, and the parallels now with the current refusal of Nokia and Advansi to offer licenses to the automotive sector. And of course, automotive isn't unique. Other vertical markets dealing with IoT applications are experiencing exactly the same situation. It's becoming more difficult, not easier, to obtain the necessary licenses. So the panel this afternoon will discuss the economic implications of have-made rights and why such a doctrine undermines internal market and is contrary to Europe's fundamental rights. Finally, the panel will discuss the effect of injunctions and how these, combined with a refusal to license, are harmful to the post-COVID European economy. So let me start by introducing the panel. On our illustrious panel this afternoon. We have Brian Wild from Wires SES. And Wires is an SME providing logistical solutions for manufacturing using wireless standards like LoRa, Wi-Fi, and Bluetooth. Virtually sitting alongside Brian is Marianne Fredenlund from Nordic Semiconductor. Nordic Semiconductors are a European semiconductor company, a global supplier of IoT chips. And by the way, they're a vendor to Brian. And last but no means least, we have two legal experts from Germany with extensive practical experience with the refusal to license SEPs and the impact of this on their clients and on industry at large. We're pleased to have Jochen Gerstein, partner in Graham, Linz and partner, Dr. Frank Enrich Hufnagel, who's a partner with Freshfields, Buckhouse and Deringer. So in sum, I think we have a great panel to communicate some important messaging on the refusal to license and the effects this is having on innovation in the IoT system. So let me turn now to our first speaker. The first speaker is Frank Erich Hufnagel, who is head of Freshfields Patent Litigation Group in Dusseldorf. Over his more than 20 years with the firm, he has built a remarkable patent litigation record for many large corporations in various fields of technology, with a particular focus in pharmaceutical and telecom sector. Frank Erich represents Continental in its SEP dispute with Nokia. So turning now to Frank Erich. Frank Erich, you're a litigator with an understanding of the dynamics of play. Can you help us set the scene in the panel by taking us through the issues with SEP licensing from your perspective and bring us up to speed with the status of the legal dispute? Frank Erich, over to you.
Yeah, thank you very much, Jim, for this kind introduction, and happy to give it at least a try as a litigator. And when talking about the refusal to license and being a lawyer, let's start with the law, and let's start with the right that is being refused, and that is the right to a license, the very starting point of this dispute here. Is a starting point that seems to be fairly uncontroversial right. The very background of that right is the, again, uncontroversial correlation, as you like, of a standard essential patent or a patent becoming part of a standard. And in return, the owner of that patent commits to grant a license to any willing licensee. And the flip side of that, of course, is the right of any willing licensee to obtain such a license, to get such a license. And that principle as such is fairly deeply rooted and enshrined also in case law. I mean, we all know the European Court of Justice case law on this, Huawei ZTE, which fairly clearly speaks about the justified expectation of any willing licensee to be licensed to these patents. And even in the most recent German Federal Supreme Court judgment of May in Sisfeld versus Haier, for many reasons, highly controversial judgment, even there, the court is utterly clear in that it acknowledges a legal claim for the licensee to demand a license from the SEP owner. So that concept seems to be fairly clear in the law. We also know, and we heard about that already, it works in practice. It works in practice to the extent that also component manufacturers are getting licenses from SEP owners. So there is no uniform refusal to license here. And very recently, we have seen in the automotive litigation, a license being granted from Avanci member Sharp to Huawei. And that license covers all components that Huawei manufactures, down from the chip through the NAD or all the way up to the TCU. So without distinction here. So again, it's a concept enshrined in the law and working in practice. So what's the problem, one could ask? Well, the problem is a strategy that has been developed recently by the SEP owners and has played out very heavily in the automotive disputes that essentially consists of two elements. The one is a legal argument, and it is a slight reconstruction of the right to license. And the slight reconstruction is that the right to license is understood by the SEP owner as not really a right to a license, but a right to access of the technology And access of the technology, that is the argument, can be achieved by other means of licensing any willing licensee. And that opens the door then for the argument that it is sufficient for an entire value chain to get access to patented standard essential technology by licensing only on the final value, on the final level of the value chain. And that is combined, that legal argument, with the procedural strategy. And the procedural strategy, again, we heard about that briefly in the first panel, that is to file a suit against not the component manufacturers, but the manufacturers of the final end product. And that has become fairly spectacular in the automotive industry, where those final product manufacturers are the car manufacturers. And that has led to those, Sabine mentioned that, to those very prominent injunction decisions against car manufacturer Daimler here. And here, again, this strategy has been fairly successful, at least initially in Germany. And why is that the case? On the one hand, again, a point that Sabine mentioned already, it is the boldness of German courts to render injunctions wherever there is patent infringement, even in case of standard essential patents. And secondly, a fairly unanimous refusal, at least by the courts in Mannheim and Munich, to take into account the willingness of the suppliers of the car manufacturers to take a license, the suppliers to take a license for their components, and to, well, essentially regard that as irrelevant, and insofar and as long as the end manufacturer, the car manufacturer, is the defendant in the litigation. So that is a bit the litigation scene that has been set. The most recent, perhaps the most recent twist of that I don't know to which extent you're aware of that, is that this refusal to license has been slightly modified. It has been qualified, particularly by Nokia, in that it is not a full refusal to license suppliers anymore, but an extension of the offer to license to tier 1 suppliers, but not further upstream the supply chain. So in other words, TCU manufacturers and car manufacturers are entitled to ask for a license. NED manufacturers or chipset manufacturers are not. So that is the restricted licensing model with which the SEP owners have now entered the scene here. And that begs the question whether this restricted licensing model is not something that could be regarded as sufficient. Well, I think it cannot, for a number of reasons, and I would just very briefly mention 3 of them. The first is that this restricted licensing model has the tendency to distort the valuation. We heard quite a bit on that issue already in the first panel. The essence of that is that there is a tendency to regard the connectivity value, or what the SEP owners claim as being the connectivity value, as the basis for license fees. And that is definitely not identical to, in fact, it's far higher than the intrinsic value of patent technology, which should be the basis for licensing. Second problem with these restricted licensing models that are being offered now is the harm for innovation. That harm for innovation results from the limitations of these licenses in terms of substance that we call field of use limitations. These limitations can be, and in fact are, fairly substantial. So the automotive licenses that are currently being offered are licenses limited to connected cars up to 8 passenger seats. So even a bus would not fall within the realm of the license anymore. And that, of course, creates all the sorts of problems that we heard about, because it leaves a wide area of research and development of the component manufacturers outside the field of the license, and of the clients that we have been working with. To name but a few examples, it's ideas of developing concept for, well, from intelligent traffic lights to smart farming machines, from autonomous utility vehicles to unmanned flying vehicles, all of that based on connectivity technology developed by those component manufacturers, that would be outside the realm of these narrowly limited licenses. And that leads to the final and third point or problem with restricted license models that I would like to touch upon here. It's the loss of commercial independence of the component manufacturers, because they depend on the license of their customers. But that is something that I understand Joachim will also look into a bit further when he talks about the have-made rights. So those are the limitations. And I think the bottom line is that it should not be for the SEP owners to determine the business model of the component manufacturers, but for the willing licensees to choose their business model. And that leads me to the final, very brief point only. What is the current status of the dispute, and is there any hope at the horizon? Sabine was already fairly pessimistic about that, and I'm afraid I'm not much more positive on that either. We can perhaps discuss that further in the discussion, but I would just like to very briefly look at where could such a solution come from. Could it come from the antitrust authorities? Well, not very likely. The EU Commission has a complaint on the table for 2 years, and for political reason does not really seem to want to touch it. The German Bundeskartellamt has already gone fairly far by filing a amicus curiae brief, which has been largely ignored by the court, quite remarkably, but won't go much further, I'm afraid. The referral to the ECJ, I'm afraid I have at least bad news in terms of timing for you. It was supposed to come out this Thursday, but yesterday it has been postponed by the Düsseldorf court, and the decision will now be announced on the 26th of November. So only then we will know whether the Düsseldorf court will make a referral or not. And then finally, are there any options in national courts? I'm afraid it's much easier to convince the courts of rendering an injunction than to whet their appetite for economic analysis and rate setting, as we have heard. So the current state of play seems to be that we are unfortunately still fairly far away from a balanced system. Thanks, Jim.
Yeah. Thanks, Franz. Thank you. The second speaker is Joachim Gerstein. Joachim has been a patent attorney since 1998, and he's managing partner of the IP law firm Grams, Binz and Partner, located in Hanover and Braunschweig in Germany. And beside prosecuting patent applications in the field of electronics and electrical, mechanic and design and trademark applications, Joachim is very active in patent litigation. He's extensive experience in defending suppliers against claims from standard essential patents. So turning now to Joachim. Through the cases you deal with, you can see the harms and market distortions restrictive licensing causes. Can you provide us with an insight as to how the monopoly right of the patent, in your view, is being misused, and give us some of your examples? Thanks, Joachim.
Yes, thank you for the invitation. And I would like to add, answer your question and add something to Frank Erich, who opened the floor for from the legal perspective. First, as patent attorney, I would like to draw the attention where we are talking about. We are talking about the monopoly right of the patent. And then that's the question, what's the monopoly right, what's patent deal with, and what is then allowed to license? So the in Article 28 TRIPS, it's clearly mentioned that the manufacturing, offering and sale of the subject matter of the patent, so the subject matter of the claims, that's what's granted with the patent, and this can be subject matter of the license. So a patent owner, including an SEP owner, has the right to grant a license for the manufacturing of what's the subject matter of the patent, and not granting a license to the manufacturing of a vehicle as Avanci does. And I would like to show, to remind you on a very old decision of the European Court of Justice, it's windsurfing international decision. It was related to a rig for a sailboat, and the patent was directed to the rig, and the European Court of Justice clearly pointed out that a license focused on the surfboard, so the broader like the vehicle, is an infringement of the antitrust obligation. This goes beyond the scope of the patent. This decision was related to a standard, to a usual patent. It was not a standard patent, but it shows what the patent laws define. The patent law is you have to look to the claims of the patent and what's the monopoly right, and this is what to license and where to license. So when we discuss where to license in the value chain, my answer, there's no discussion. The patents are clear. They are directed to communication devices, they are directed to transceiver devices or user equipment, or to the system. So you have to grant a license for 4G to the network provider and to those who manufacture the computer program and the communication devices. That's who are implement the technology. And this leads me to the second point, which is also here important. And it's clearly in the case law that everybody acting in the business has the obligation to avoid patent infringement, and he is obliged to do this on his own. So if you are using standardized technology, what you can do, you can either get an own full SEP license, then you are free, you fulfilled your obligation to take care avoiding patent infringement. You can persuade already licensed electronic devices from your supplier, and then the patent right will be exhausted, and you also fulfilled your obligation, or you stop infringing the patent by stop using the technology. You don't have any other choice. There's no other fourth choice. From the patent law perspective. So if the manufacturer who manufactures the communication modules like NADs, if they don't have an own license, they do illegal patent infringement business. And if they don't take care on patent license, and if they are refused to get a license, they have to stop business, or they have to ask for an irrevocable and legally binding declaration of all SEP owners that they do not assert any claims against the implementers. But the situation as it is, that the SEP owners say we won't grant a license to the manufacturer, doesn't help, because they still have the risk in their books. And they also have the not only the risk, they have the obligation due to the sales law, due to their sales contracts. They have indemnification clauses towards their customers. And so the problem is not solved by the Avanci pool, because the upstream manufacturers still infringe, and they are not able to avoid patent infringement. This has a reasonable effect in the market. The manufacturers, they sell not only directly to the suppliers for automotive industry, for example. My client Bury, for example, they buy for small numbers of products. They are highly developed, highly specialized in their product, and they sell products in smaller numbers as Continental does, and they purchase in a huge amount electronic components from cross-sellers, not directly from the chipset manufacturer. And this is the problem, that you can't pass through the indemnification clause through the cross-seller who doesn't know anything from the technology back to the module manufacturer. So, and this leads to a market distortion. As we now learned from the Daimler disputes, we learned that the communication module manufacturers who holds its own significant SEP portfolio, they have much better opportunities to more strengths to get a license. As Frank Eric told, URY was licensed by Sharp, and Sharp is willing to license also on the module level, on the module manufacturer level. We have to see if they are really agree on licensing the other smaller manufacturers like Mublox and so on. We will see. But for the time now, I advise my clients not to purchase modules from the small manufacturers, and in particular not from the European manufacturers. It's more interesting to purchase from the strong manufacturers like URY. And what we learned from the Daimler case is URY settled. The case is over for all suppliers using URY modules. For those who used the other modules from smaller manufacturer, the case might go on. So that's a problem. And so it's and you have to take a look to the Chinese jurisdiction. It was recently published that URY settled with Conversant. And the basis was a Chinese Supreme Court decision hindering Conversant to enforce their German decision against URY. And this leads to the settlement. So where the game is maybe decided is not in Europe. The game will be decided probably in China. And we have to closely look to the Chinese court decisions and how the Chinese courts set the rules. It's not only Europe who sets the rules. Here we see Chinese are faster. So, and finally, I would like to draw attention to the established business practice. We heard this earlier in the statements. It's well-established practice that the first manufacturer gets a license granted, like Sysvel. Sysvel recently licensed Mublox, so that they are open to grant a license to the implementer. Or as we heard, Sharp and URY, they get a license. So it works. But the question is, why doesn't it work for all SEP owners? Thanks.
Yeah. So Joachim, thanks very much for that insight. That does raise quite a number of concerns. So we've moving now from the legal insight from Frank Eric and Joachim now to the industrial part, where we've got our third speaker is Brian Wild, and Brian is a fellow Scot who's moved his company to the French Alps, I understand, in search of better weather. Brian holds multiple patents and experience in developing technical IoT solutions from the hardware level right up to cloud-based applications, which has proved to be very useful in designing within the networking business. So Brian, turning to you now, personally, you've got a number of patents to your name, but you're also heading up the technology decision process for your company. Can you help us from the SME perspective? Let us know how you view the patent SEP system with respect to your technology choices. Brian, over to you. Thanks.
Okay, well, thanks, Jim. Thank you for ACT for this opportunity. As Jim said, I'm was CTO of Wires, a startup in the French Alps. And before that, for Eloquent, who are another startup doing telecoms in the French Alps. And before that, I worked for Hewlett-Packard, who were obviously a large company. And in all of those companies, I developed and submitted patent applications. I think I have 7 or 8 patents with my name on them. If you look at Wires as an SME, we are a very small SME. We're 10 people at our biggest. So all of the legal aspects related to IPR, to intellectual property, and in particular to patents, were all via either my experience as a non-lawyer. I have no legal background on this apart from what I've picked up over the years. So all of our specific legal actions had to be taken by using external resources. And unfortunately, lawyers are not renowned for being very cheap. So anything that involves having to deal with patent infringement or patent cases, we try to avoid because it's just a drain on our resources. Our products, we use chipsets that do LoRa, which do Bluetooth. We have ARM processors, we have GPS blocks in there. So an awful lot of standards which are with SEPs in the works. We produce an end device which we sell to our customers directly. Now, the patents that I've been involved in over the years certainly were for different reasons. HP had a very definitive policy at the time, which was 25 years ago. They would want to have patents in order to defend themselves against other companies with patents, and it was basically a trade-off. You know, I've got this patent that, on my product. You say you've got this patent on my product, and I've got this patent on your product, so we have a deal and we sort it out, and we don't usually come to court. But as moving from a big company like that to a startup, the use of patents is completely different. We patented things, generated patents purely to make ourselves look more valuable as a startup. There was no real intention that we would be able to use those patents to gain money and licensing them. And they were really to look good to investors. And in particular, we have maybe 1 patent, 2 patents. Obviously, that's not a patent pool that you can use when you're talking to a licensee who comes and says, you should have a license on this patent. So all of this has given me a background, a view on perhaps the patent system in general in the EU and worldwide, which is definitely not a legal view. But my view is that for SMEs in particular, patents are a bad thing. I know that patents are supposed to give you return on your investment, on your research. For an SME, clearly, from my point of view, this is not the case. Patent system currently, especially with the advances in software patents, are just a bad thing. It's a lose-lose for an SME. If we spend the money to produce patents, it's money down the drain mostly. And if we are attacked, those patents generally, we don't have the legal resources to protect ourselves. So our only option generally is to pay up. I think the entire patent system currently has, certainly in the last 25 years, gone in a very difficult direction for anybody who is on the receiving end, on the SME end. It's a plaything for large companies, and an SME is just lost. We can't deal with, dedicate the resources necessary to navigate that area. So I would say that patents in general are, for an SME, pretty much only a danger. They're not an opportunity. When we come to standards essential patents, then I'll say I have a lot of opinions on that. I completely agree with the experiences as noted by the first panelist, by Dr. Henkel and with Mr. Van Dost, about standards essential patents. If you're producing an item where you're trying to use a standard, standards are a good thing in technology. I sat on several standards committees, producing standards for the IETF, for ITU. Standards are a good thing to help technology work and to produce things that people use. And by encumbering them with SEPs, you basically are causing a problem down the line, because a company who is a startup, they want to use a Wi-Fi chip, they want to use a 5G chip, they want to incorporate that into their innovative product. They have no choice in many cases but to use the standard because otherwise their product will not work. And to then say, oh, okay, you want to use this as a block in your system. It's not even the innovative part of your system. It's merely for communication. But when you use it, you'll be getting calls from people who will be saying, we have an SEP, you have to license, and we want a license based upon a percentage of the final value of your product, the final cost of your product. For me, is just beyond the bounds of what is reasonable. This is not research that's getting a fair return for the research they've carried out. This is basically extortion. I think that there is definitely room to move on how the standards committees and the patent system needs to change if we want to avoid, and I think what I've heard from all the other panelists so far, what we want to avoid is where this simply stifles all innovation and nobody can move. I would say this is a failing of both the patent system itself, which lets through an awful lot of patents where the only innovative part of the patent is the language that's being used by the patent lawyer, and also of the standards committees. It should not be reasonable for a standard to be encumbered by standards essential patents that have not been validated as actually being used in the standard. That is the standards committee, I would say, not doing their job, and that should not be allowed. As you say, I'm not a lawyer. I don't have a way to say that this is true, but on the other hand, this is my opinion of how, as an SME, I come to looking at trying to incorporate technology into my products. And basically, when it comes to a standard which has SEPs on it, I cannot spare the time to deal with working about, do I need to get an SEP? Where is the license coming from? Up to now, we've been working with technology and, where basically, as has been said, we buy the components, I buy my components on my card. And when I buy the component, effectively, the license is being paid by the component manufacturer. It is being, when I buy the component, I buy the right to use it. This gives me the occasion to say, okay, I've made my card. I put a LoRa chip on it. I put an ARM chip on it. I've got memory on it. I've got an accelerometer on it. It doesn't matter what standards are in there and what that does. There is no possibility for anybody to come along and tell me that I have to pay a license because I bought the chip with the license. And that is essential for me as an SME to be able to use that technology. To sum up, I would say that the way I see SEPs and the way they're used in standards, it's just a club trying to get, basically trying to get money out of people for no real reason. It especially annoys me when I see companies that do nothing but hold patents. They never produce a product. There is no way to say, okay, I've got a patent that might infringe, you might be infringing as well, let's deal. They're just there to extort money. If this doesn't change, I think that the use by SMEs of new technology will be stifled. Clearly, I would not want to use a chipset or a product or a standard that I didn't know wasn't covered already by a license. And I would definitely not want to incorporate it into my product and find out after I've done all the work to get out to customers and make my sales that somebody's going to come knocking on the door and saying, I want X% of your final sales. I would, in that case, say, I'm not going to use that product. I'm not going to go into this area. I'm not going to try and innovate and use the advantages of a standard if that's what's going to come down the line. It's hard enough setting up a standard, setting up a startup and dealing with all of the issues you have starting up a company without also having to work out whether there's going to be a legal issue and a licensing issue that's going to come at you down the line. And that needs to change. And the way that needs to change, I think, has got to be something that the European Parliament can do, because this is something that will be negatively impacting the public, especially in Europe. And I think the European Parliament has to deal with the fact that people who are the end consumers of these products will be being penalized by the way the system is working right now and by the direction, certainly by the direction of travel in the whole SEP and patent system. Yeah. And I think the European Parliament has a responsibility to the public to try and work out what can be done to fix that. And obviously I have lots of opinions about how that should be.
Well, Brian, that's great. So we thank you very much for your opinion in that case. And that gives us time now to move on to Marianne, who is the other part of our industrial complex here. Marianne is hailing from Nordic Semiconductor. Marianne's a legal director, and over the course of her career, Marianne has gained a unique in-house perspective on IP-related business practices within the wireless ecosystem. Marianne, you represent an experienced semiconductor manufacturer. Can you provide us with an insight into your company's global operation and some of the and leading on from what Brian said, can you give us some of the practical difficulties you've experienced with cellular SEPs? Marianne, over to you.
Yes, thank you, Jim. Listening to Brian is this is exactly what we wanted to solve and be able to provide him, that the small SMEs could really take advantage of our technology and implement that and not be bothered with these kind of questions related to standard essential patents. And we could have our 200 engineers in Finland who work with and develop our system in package with cellular functionality. They could do this for him and negotiate a deal that would definitely be more FRAND than we believe that Brian would be able to do. So that's an introduction, but Nordic Semiconductor is a Norwegian company with a global presence. We have approximately 900 employees around the world with 600 engineers, and many of which participated in the development of the 4G standards and LTM and NB-IoT. We invested 1/3 of our revenue in R&D in 2019, and we have more than 200 patent families. So we committed to the SSO to extend licenses to anyone who wants to implement the standards, and we intend to keep that promise. We have long-standing distribution agreements with distributors and their subsidiaries worldwide. By utilizing this network, we reach out to all corners and thousands of customers around the world, shipping over 1 million Bluetooth system on chips per day. We want to adapt that business model to the cellular business, but we've had to renegotiate and carve out liability for cellular technology. And not everyone in the supply chain has been able to do that. Long-standing agreements with utility companies with set prices for 5 to 6 years and indemnity obligation causes disputes between smart meter companies and their customers. The whole supply chain is disrupted when the smallest component implementing the standard is refused access to third-party IPR. If a component manufacturer like Nordic Semiconductor could get licenses to SEPs related to 4G based on our module, we could have priced that into the module and could sell licensed products to all customers, no matter what kind of products they produce. Unfortunately, some of our collaboration partners in the SSO did not keep their promise and through negotiations have refused to license us on module level. And none of our customers or their customers are licensed either. There are currently no licensing programs for 4G in IoT except for the connected car. So our module is application agnostic. All customers get the same price, only depending on volume they purchase, and we do not charge differently because it is the same radio connectivity they use, whether they make a smart meter, an asset tracker, street lights, or Brian's product. Maybe a couple of customers will be licensed. If you could switch to the next slide, please, Alex. Thank you. So maybe a couple of customers will be licensed for one or few of their products when the licensors decide which one of these companies have a product that they want to extend the license to. Licensors abuse the market power achieved by SEPs by choosing which companies in the supply chain to license, thus which companies in this industry that can be compliant and not in breach of relevant laws, such as the UCC that Dr. Henkel mentioned, or local patent law. And they decide which companies who can compete in the market because they lack licensing of essential IP. When I hear that Huawei has achieved a license, no, I mean, that's because they have a huge patent portfolio and they have much better leverage negotiating a cross license with the Sharp than other companies, which is also anti-competitive. And while the licensors can discuss and agree on a royalty rate that they believe is fair for one vertical, the implementers cannot discuss rates on what is a fair and reasonable price due to competition law. So none of our customers are currently licensed, which means that we do not have any have-made rights from our customers, which is the licensor's main argument and grounds for ignoring us in their license scheme. When customers do not have a license, it's comforting for them to go to a supplier who extends indemnification. But the licensors don't want to deal with the component suppliers, and we can assume that the royalty rate will be based on the customer's product. So will these suppliers be able to honor that indemnification? And if the component manufacturer is able to get access to a license for some customers, will they have to pay a royalty rate based on their customer's product? This forces SMEs out of competition, as the risk of indemnification is too high and too expensive compared to the product price, which is around $12. Well, we have been requesting licenses and not been able to obtain that on module level through negotiations. Many customers have taken the risk to design in cellular technology. And customers now shy away from marketing and promoting their new products with cellular functionality, afraid that licensors will come after them. Our goal is to get access to licenses to all customers, including Brian's product, and to the technologies, all the technologies that we implement. And I'm optimistic that we will get access to licenses on one way or another, but afraid that it will take time in a fast-moving IoT industry. So if licenses do not become available, customers will be looking into using other technologies, developing their own technologies, instead of adding a risk contingency that will make them less attractive in the market with regards to pricing and with the constant risk of injunctions and litigations. Thank you, Jim.
Okay, thank you. Thank you very much, Marianne, for that. So let's turn now to questions. We've got a number of different questions here. One has come up. Firstly, let me put a question to the our legal side of the panel. Frank Erich, you made a statement that there's a right to license in every level of the value chain. But isn't this just impractical? Would it not be more efficient to focus licensing in the final product level in order to create certainty as to which products are licensed and which are not, and reduce transaction costs for licensing? That's one of the questions that's there. And by the way, since we're talking about automotive, I've also got a question. I'll just slip this in as part of that. This is to yourself and Joachim. We have 15 car manufacturers, including BMW, Volkswagen, and Audi, who have already taken a license for 4G and 5G patents, and Daimler has not. Discuss. So over to Joachim and Frank Erich.
Yeah, happy to take up and give it a start very briefly on the second question. I think it's a question of counting. I mean, if I count correctly, I rather count 3 or 4 car manufacturers that have taken a license, because most of them belong to the VW group. Audi, Porsche, I think Scania, they all belong to the Volkswagen group, and besides that remains BMW and Volvo. And you have about 200 more out there that have not taken an Avanci license. So take that, whatever you like you want to take out of that. And if you also know that VW has been the first victim of tech versus automotive litigation in Germany with the Broadcom litigation 2 years ago, and we're the first one to experience what it means to be under the threat of an injunction German style, that may have created some sensitivity in Wolfsburg. So to me, that doesn't really create an industry practice. And that leads then to your question, Jim. Also, very briefly, it has been a common argument by the SEP owners that this be more efficient. But in a sense, I have given already the answer. If you think that there are about 200 car manufacturers out there, why should it be more efficient to try to license all of them rather than a handful of tier 1 suppliers, or even less NAD suppliers, or even just 5 chipset suppliers? And I think Marianne gave the answer to that with her wonderful slides. and how much life could be easier, in particular if you think of IoT applications, if you had licensing on the first chipset component level.
Okay, thank you. And a quick follow-up to that. If there's a right to license, why don't the component manufacturers simply sue the SEP owners for a license in the courts?
That's a very good question. But honestly, as a litigator, that is one of the things I've been thinking about a lot recently. But to some extent, the experience is that courts like to do what they can do. And they can issue injunctions. In particular, German courts can do that. Whereas what courts cannot do, and do not like to do, is delve into deep economic analysis, because then they would have to listen to learned people like Professor Henke to educate them on valuation. They would really have to understand what Roya talked about, top-down versus comparative licensing and all of that, and they would have to embark upon rate setting. And apparently, apart from the British courts, no court in Europe has had any appetite so far for that. And that's what it is. It's just simply much more difficult to file an action with prospect of success, the aim of which is not just simply to forbid manufacturing of a product, but the conclusion of a license contract.
Okay, well, that's good. I'll come back. I'll switch now to the industrial part of our panel and ask Marianne and Brian a question. And Marianne in particular, there's a number of 4G, 5G technology companies are messaging, along with a number of the semiconductor analysts, that the way forward for the semiconductor industry is not necessarily to make money out of selling chips, but to make more money out of IP licensing by controlling licenses. So why hasn't Nordic Semiconductor followed suit? Are you guys missing a trick?
No, we haven't, and we're definitely in that game. But I think there's a difference between, there's a clear distinction between having a right and having a license than having an access to a license. When you have an access to a license, you're just passing on rights to another company, while if you're licensed, you have the opportunity to have the freedom to operate. And we still have to agree on what end products to license, and that's going to take a while. If you look at that's taking what, 4 years to license connected cars, and we're probably going to see more products being licensed in the IoT sector, such as the smart meters, but it will take time. So yeah, it's not the same. It's a risk mitigating action is to have access to licenses, while a risk eliminator is to be licensed.
Okay. So just taking up a little level and looking at semiconductors in Europe, I was recently made aware of the fact that the President of the Council of Europe, Charles Mitchell, made a presentation at the FT conference, and he was talking about European sovereignty. He mentioned the cloud, that Europe needs to get better with the cloud. He cited 5G as ubiquitous 5G was necessary for the progressing Europe. But he also mentioned semiconductors, and he mentioned the fact that we need more European semiconductor companies. And his words were, these are the basic elements of the value chain connecting objects, cars, and phones with edge computing, which I think we all agree with. Aren't the licensing regimes today going to be a barrier for the growth of new European semiconductor companies?
Yeah, I believe it does. China is not only leading in the 5G development, they are working on alternative standards to 4G, to NB-IoT. And they are subsidizing their local manufacturers, local foundries, semiconductor companies through their China Integrated Circuit Fund. And while we in Europe argue over SEPs in court, the Chinese are well positioned to fuel the world of IoT with their technology.
Okay. So switching back now to the legal part, I've got a couple of questions in here about the Unwired Planet versus Huawei judgment. One of the questions is, what are the realistic practical consequences of the Unwired Planet versus Huawei judgment? And is it likely that UK courts will be an attractive place to enforce SEPs? And is there any discussion of this or a litigation strategy over there in Germany? Joachim, Frank Eric, do you want to respond to that?
Yeah, what's a litigation strategy over in Germany? It's quite difficult because we have one Supreme Court decision now in place, but it's open how the courts decide. So there are different courts deciding in different ways. So it's difficult, as we learned from the URY conversion case. I think better to try to solve the issue in China, and this would be my litigation strategy, to go over to China and file an anti-suit injunction there, and or try to defend in China.
Perhaps just a brief addition on Unwired Planet, because you asked specifically for that. Jim, indeed, that is something that is being discussed as a strategy, because as I mentioned, that is the only court in Europe that has dared to embark upon rate setting. But it is perceived, or the methodology at least is perceived by most as being, again, rather patentee friendly, because of the focus that is placed on comparative licensing here. And so whether that perception is absolutely true, it's another question, but I think the conventional wisdom is that you're better off if you want a rate setting in the United States, or as Joachim said, perhaps even think about China, and that is what we currently discuss. But the United Kingdom is always on the agenda of litigation strategists.
Okay, well, it's good to know, but good for something then, Eric. So one final question, because we're about to run out of time, and I'll turn to Brian. Brian, as an SME, when your company is considering the use of new technologies like 5G, are licensing issues something that determines whether you choose that technological solution or not? Does the standards, the licenses come into your technology choices?
It's true that I think the problem is, previously I would have said I was going to buy a component or module, and that would be covered with the licenses. Sadly, having put the toe into the waters of the licensing around 5G, and in particular when I was participating in the DIN best practices for 5G for SEP licensing, it makes me very worried. And I would certainly not want to use a technology like 5G, buying in a component or doing implementation, if I wasn't very clear on the fact that I wasn't going to have to negotiate as an SME directly with an SEP license holder, or many SEP license holders individually or as a pool. So I would definitely say that no, I would say I will use something else if I can, and if not, I will certainly be looking for a component manufacturer who can give me the guarantee that their module has the license for my application. So unfortunately, if Nordic say we cannot do that, then I would have to go and look for a different manufacturer.
Okay.
We use Nordic for Bluetooth, and I know that my license requirements on that are covered by Nordic, and so I can use it as a component. I'm not innovating, I'm not implementing it, but I can use it directly to make my product. 5G, if I don't have that guarantee, either I'm going to go and have to find a component manufacturer who can give me the guarantee, or I'm going to have to use an alternative technology and maybe not even launch my product.
Thank you very much, Brian. We'll have to wrap up now, so I'd like to thank the panel for an interesting discussion. I still think there's an opportunity for hope here. I know that people have been a bit down in terms of where the situation is going, but I think we're now got a new president in the White House, or we'll hopefully have a new president in the White House, and the vaccine is looking more positive. So hopefully we can do something in the IP, SEP area and move the discussion forward. I was bolstered by the fact that the European Commission has a good understanding of the issues. The thing that came out for me in the presentation was very much that they recognize the urgency of the situation. This is not something that can keep going on and on. We need to do something about it today. So thank you again very much for your interventions. And I'll hand back to Alex. Thank you.
Thank you, Jim. And thank you to the panel. Wow, what a great panel. So much to think about following that. I'd like to offer, in my closing remarks for the day, I'd like to thank our sponsoring MEP, Mr. Garcia de Blanco. I'd like to thank the Commission and Mr. Slavomir Tokarski for taking part. And of course, I'd like to thank the panelists. I think each of them gave wonderful interventions, and I very much appreciate their participation. So we will be having more events in the future on not just SEPs, but on intellectual property rights in general. So please stay tuned to our Twitter and to our website for more updates on that. So with all that said, thank you again to all the panelists, to the audience as well for your participation. We look forward to welcome you to our further events. Bye for now.